Your Honor, today I would like to be arguing the case LW v. Skrmetti before you. Your Honor, in this case, the state of Tennessee has banned all uh, transgender care for minors, effectively banning the ability of minors to physically transition to their chosen gender or to obtain gender affirming surgery. So there are two arguments that I would like to make before you, Your Honors. The first one is that under the Equal Protection Clause, you simply cannot single out for separate and discriminatory treatment a discrete and insular minority because that's forbidden under the Equal Protection Clause. So the state of Tennessee, I'm sure, will argue that being trans is not a protected category. So let me make this argument. What if, Your Honor, the state of Tennessee had outlawed all medical care for black minors while allowing minors of every other race to obtain medical care? Now, obviously, that would violate the Equal Protection Clause. So the state of Tennessee will argue that being trans is somehow different from being black. But let me posit this hypothetical for you. Consider if the state of Tennessee had outlawed all care for minors where that medical care involved the treatment for sickle cell anemia and had justified that law on the basis of arguments based on health studies that the common medical treatments to treat sickle cell anemia are unsafe, which I'm sure the state of Tennessee is ultimately arguing that this medical care is unsafe, and that is why it's okay for them to do this. So, sickle cell anemia is a disease which, according to studies, disproportionately affects black people and communities of color. So, if the state of Tennessee were to do this, they would have passed a law that would be justified on the basis of the underlying health care provided and its safety, but that law would not be constitutional because it would violate the Equal Protection Clause because it would be unfairly targeting black people, which is a protected category. And under the United States Constitution, you simply cannot single out black people for separate treatment. That's not constitutional. In today's day and age, we're long past the day when that was okay, when that was viewed favorably. So we're beyond that now. So my argument is that singling out trans youth and preventing them from being able to get the treatment that they need and being able to get the health care that they need for their condition is absolutely analogous to the state of Tennessee singling out black youth and preventing them from getting the medical treatment that they need because they're black. And to argue that the safety of the procedures is the justification does not actually justify conduct that violates the Equal Protection Clause. The safety of healthcare is not in the Equal Protection Clause as something that it lists as an exception to what it covers. So the state of Tennessee simply cannot do that. Now, my second argument is that this common argument against medical care for trans minors and gender affirming treatment for trans minors, which I'm sure the state of Tennessee will make, which is that the studies show that a certain small percentage of minors who receive medical care as minors to transition later go on to regret or quote unquote, have regrets about their actions, and they then transition back to the gender that they were assigned at birth. And so the argument of the state of Tennessee will be that uh, minors should not be able to make this decision because they may later regret it. So they shouldn't be given the freedom to make that choice because they may end up regretting it. And then the argument is that, of course, in certain respects, gender affirming care for minors cannot be undone, the effects cannot be reversed. So let me make an argument to counter this misconception. And this argument particularly applies to healthcare and the issue of medical care, which cannot be reversed, and whether the argument that you may later regret the decisions that you've made with respect to your healthcare, which you view as turning out to have been wrong and which cannot be reversed, is a justification to deny you the freedom to make that choice, particularly with respect to minors whom the law considers to not be as mentally capable as adults. Now, of course, that's not always true. I'm sure there are plenty of minors who are smarter than certain large sets of adults in today's population, but this is what the law says. So let's assume that that is true for the sake of argument. So consider this hypothetical. There's a minor and they have an infection in their leg, and the doctor tells them and their parents, their entire family, that they will have to make a choice about whether to have their leg amputated. The doctor says that with the treatment of certain antibiotics, there's perhaps a chance that the bacterial infection can be reversed and treated successfully. But if those antibiotics fail, then this minor may die. But if they choose to have their leg amputated, then there's a much better chance that they'll not die from this infection, but then they'll have to live the rest of their entire life with, one leg. So let's posit this decision. Now, what if the decision is taken away from the minor, and the parents make this decision for the minor against the minor's wishes and without consulting with the minor, and say the minor wants one thing, but the parents want something else. So of course the parents get to decide and impose that on the minor. Or say, for example, that perhaps the doctor or the state imposes a decision on the minor. Now, we may say that the minor lacked the mental capacity to make this decision, although it's a fairly simple decision to make conceptually. So there's no intuitive reason to believe that, like, a teenager would be unable to understand the concepts of like having their leg amputated if they're like mentally normal for that age. But even if they were, not as mentally competent as the adults in the room, um, consider what would happen if this decision is taken away from the minor and the parents make it with no input from the minor or against the minor's wishes. Now, the doctor has said that there are certain probabilities involved, and the doctor doesn't know for sure what's going to happen. So the parents are making this decision without knowing what the result is going to be. They don't know if the antibiotics are treated, whether that will in fact cure the bacterial infection. So they don't know what the quote unquote right thing to do is. In terms of this hypothetical, there is no knowledge of what the result is going to be. So you can't know what the right decision to make is. So say that the parents choose to have the leg amputated, and then but the minor didn't want the leg amputated. So this minor then grows up and becomes an adult, and they live their entire life with one leg, even though they didn't want that to happen. The parents forced that upon them. So they become adults. They didn't want to have one leg, but then as adults, this person is forced to live out their entire adult life with one leg, even though they didn't want that and that was against their will. And consider that the parents didn't know what would happen if antibiotics were used to attempt to treat the infection without amputation. Now, and also in this hypothetical, let me be clear: the doctor is saying that both of these are valid medical options. The doctor has said that the doctor himself does not prefer one or the other as a medical solution to this problem. Um, because I mean, having your leg amputated itself carries certain health risks and health defects, which sort of were equal to the risk of treating it with antibiotics and curing it, or dying from it. Especially when you factor in loss of income from an adult living their life with only one leg, and the loss of income that comes from that disability. So now this minor their entire life is affected by this decision, which was taken away from them. And there was no right answer, and the parents had no way to know what the quote unquote right answer was. So, my argument is that when the state takes this decision away from minors of whether to get gender affirming surgery, that's the same thing. And the minor should have some input into what's going to be done to them that's going to affect their entire adult life because that's the right thing to do. And the argument that the minor might have regrets as an adult, well, either way, the minor might have regrets as an adult. If the person is forced to get the amputation, and then they might have regrets later on as an adult with one leg, or they might not. If they if they choose not to get the amputation, they may die or they may not. But if they don't die, then they probably won't have regrets. If they die, then they're dead. But if they're forced to get the amputation, they may have regrets or they may not. And then if they are forced to not get the amputation and then they die, then they won't have regrets. They'll just be dead. So this argument that the fact that people may have regrets is an argument against allowing minors to get gender affirming surgery is a straw man, because with any important and serious medical decision, you never know what's going to happen in advance. So you always have the risk of regrets. And with serious medical decisions, the consequences are always enormous. So there's always the potential for, huge regrets and life guilt that you feel like your life was ruined because you made the wrong decision about what healthcare treatment to make. But that decision had to be made, and the risk of regrets was always going to be there. There's no way that the state can change, the nature of healthcare so that there isn't risks involved and so that people don't potentially have, regrets. So the risk of regret was always going to be there. And regardless of which option was chosen, the risk of regret was always going to be the same. You were going to have the risk was that you would completely and regret what you've done, and you would have total regrets and total life guilt. That was always the risk, and regardless of which choice is forced upon the person, that is the risk, and that level of regret is the risk, is the regret that is risked. So to say that the state can prevent minors from being subject potentially to regrets is false. Now, let me then dive into this in a little bit more detail. So, considering my argument, which set of regrets is the state attempting to prevent? The state is attempting to prevent a subset of regrets for people who transition and then have those regrets that they transitioned and then try to change back to the gender that they were assigned at birth. There's a whole nother set of regrets, the regrets of trans youth who were forced not to transition and who were then unable to successfully or fully transition later in life, and who then regret the fact that they were deprived of the opportunity to transition in their youth at a time when it was most feasible for them to physically and biologically do so. So basically, the state is favoring cis regrets at the expense of trans people's regrets. And this, too, violates the Equal Protection Clause because it's only addressing the regrets of cis people and not the regrets of trans people. And so this targets and discriminates against the trans people as a discrete and insular minority in an unfair and unfavorable way. And under the Equal Protection Clause of the United States Constitution, you simply can't do that. That is unconstitutional. So this argument that the youth might transition as minors and then might have regrets about having done so as adults, this argument actually cuts against the state of Tennessee. This is an argument for why the state of Tennessee's laws are in fact discriminatory and violate the Equal Protection Clause of the United States Constitution. So for these two reasons, because the argument that the regrets of youth who transition and then become adults and regret their actions is an argument to justify this law of the state of Tennessee. And because of the underlying fact that it does violate the Equal Protection Clause, and if you did this to, for example, black youth, it would be so obviously racist and so obviously discriminatory. But somehow the state of Tennessee thinks it can do this to trans youth, and there's some like difference there. For both of these reasons, this conduct of the state of Tennessee violates the Equal Protection Clause of the United States Constitution, and it must be struck down. Thank you, Your Honor.